Hello students, I hope that you're all doing perfectly fine. In this given lecture, we're going to continue our series of lectures on the topic breach of contract. So let's begin. Now, starting with damages for breach, at the very offset, I would have you know that it has been held in Sunrise Associates versus Government of NCT of Delhi that a contract is not a property. It is only a promise supported by some consideration upon which either the remedy of specific performance or that of damages is available. And the party who is injured by the breach of a contract may bring an action for damages. And damages here means compensation in terms of money for the loss suffered by the injured party. So burden lies on the injured party to prove his loss. Every action for damages raises two problems. The first is the problem of remoteness of damage, and the second is that of measure of damage. So, starting with the first one, that is remoteness of damage, we see that every breach of contract upsets many a settled expectation of the injured party. He may feel the consequences for a long time and in a variety of ways. And as seen in Ram Kumar Agarwal versus Lakshmi Narayan Agarwal, a person contracts to where in this case a person had contracted to supply to a shopkeeper pure mustard oil, but he had sent instead impure stuff, which was a breach of the contract. So the oil was seized by an inspector and destroyed. The shopkeeper was arrested, prosecuted, and convicted. So he suffers the loss of oil, the loss of profits to be gained on selling it, the loss of social prestige, and of business reputation. Not to speak of the time and money and energy wasted on defense and the mental agony and torture of the prosecution. Thus, theoretically, the consequences of a breach may be endless, but there must be an end to liability. So the defendant here, he could not be held liable for all that followed from his breach. And it is seen that there must be a limit to liability, and beyond that limit, the damage is said to be too remote and therefore irrecoverable. So the problem is where to draw the line. Now, the case of Hadley versus Baxendale solves this problem for us, and it is a very famous case. And in UPPCJ 2012, it has been asked that critically discuss the rule laid down in the case of Hadley versus Baxendale. So, please follow the following lecture to answer this question perfectly. So, in Hadley versus Baxendale, to solve the problem, different rules were laid down, and they were as following. The facts of this case were such that the plaintiffs carried on an extensive business as miller. The mill was stopped by the breakage of the crankshaft by which the mill was worked. The defendants, a firm of carriers, were engaged to carry the shaft to the manufacturers as a pattern for a new one. The plaintiff servant told the defendants that the mill was stopped and the shaft must be sent immediately. But the defendants delayed the delivery by some neglect, and the consequence was that the plaintiffs did not receive the new shaft for several days after they would otherwise have done. So the action was brought for the loss of profits which would have been made during the period of the delay. Alderson B has laid down the following rule that where two parties have made a contract which one of them has broken, then the damages which the other party ought to receive in respect of such breach of contract should be such as may fairly and reasonably be considered either arising naturally, that is according to the usual course of things, from such breach of contract itself, or such as may reasonably be supposed to have been in the contemplation of both parties at the time they made the contract as the probable result of the breach of it. So, on the basis of this principle, the defendants were held not liable for the loss of profits. Because in the great multitude of cases of millers sending of broken shafts for repair, it does not follow in the ordinary circumstances that the mill is stopped. Even though it was pointed out that the mill was stopped and there could have existed several reasons for the stopping of the mill, the fact that the mill was out of action for want of the shaft was a special circumstance affecting the plaintiff's mill, and the same should have been pointed out to the defendants in clear terms. It should have also been communicated that the plaintiffs would have suffered unreasonable loss by way of delay. So, this decision has always been taken as laying down two rules. Number one, that of general damages, which are those which arise naturally in the usual course of things from the breach itself. Another mode of putting this is that the defendant is liable for all that which naturally happens in the usual course of things after the breach. And special damages are those which arise on account of the unusual circumstances affecting the plaintiff. They are not recoverable unless the special circumstances were brought to the knowledge of the defendant so that the possibility of the special loss was in the contemplation of the parties. So, question has been asked in UPPCJ 2015 In prelims, it said Hadley versus Baxendale is a case on, and as you all know, damages for breach of contract. Similarly, it has also been asked in UPPC's examination 2006 that the principle of assessment of damages for breach is given by, and we know it is Hadley versus Baxendale. So, in cases where no recovery or special damages is there when special circumstances are not known. So, we see that lack of knowledge of special circumstances prevented recovery of special damages in the case of Horn versus Midland Railway Company. Here, the plaintiff, a firm of shoe manufacturers, contracted to supply a quantity of shoes to a firm in London for the use of the French army at an unusually high price. The shoes were to be delivered by the 3rd of February. They consigned the shoes with the defendant railway company, telling them that the consignment must reach by the 3rd, but not that there was anything exceptional in the contract. The consignment was delayed and the consignee refused to accept it. The plaintiff had to sell them in the market at about half their contract price. In the action against defendants for the delay in delivering the shoes, they paid into the court a sufficient sum to cover any ordinary loss occasioned thereby. But the plaintiffs further claimed that the difference between the price at which they had contracted to sell the shoes and the price which they ultimately fetched, but it was held that this was a damage of an exceptional nature and it could not be supposed to have been in the contemplation of the railway company when it contracted to convey the goods by the 3rd. Now, talking about special circumstances that are already within knowledge of the contract breaker. In the subsequent case of Simpson versus London and North Western Railway Co., the above suggestion was qualified to this extent that even if the special circumstances are already within the knowledge of the party breaking the contract, the formality of communicating them to him may not be necessary. Here, the plaintiff was in the habit of exhibiting samples of his implements at cattle shows. He delivered his samples to the defendant company for consignment to the show grounds at Newcastle. The consignment note said, must be at Newcastle on Monday certain, but no mention was made of the intention to place the goods in the exhibition. On account of negligence, the goods reached only after the show was over. But as the company was aware of the object of carrying the goods there, the plaintiff was allowed to recover not only the loss of freight but also the profits he would have made by placing the goods at the show. Here, Chief Justice Cockburn said, the principle is now well settled that whenever either the object of the sender is specially brought to the notice of the carrier or the circumstances are known to the carrier from which the object ought in reason to be inferred so that the object may be taken to have been in the contemplation of both parties, damages may be recovered for the natural consequences of the failure of that object. Now, what about physical injury resulting from breach? So, the wisdom of the distinction between tort and contract principles, at any rate in reference to physical injury caused by the breach, has again been questioned by Lord Denning in the case of Parsons Limited versus Utley Ingham Co Limited. So, in this case, the plaintiffs were pig farmers and they purchased from the defendants a large hopper for storage of pig nuts. They had already purchased one from them earlier and it was serving them well. The hopper was ventilated at the top, but the ventilator had to be kept closed and was to be opened after the hopper was installed at the plaintiff's farm. The defendants negligently forgot to open it and the plaintiffs could not know it being too high. The nuts stored in the hopper became moldy and without any knowledge of the danger, they were served to the pigs. They suffered from a rare type of intestinal infection and 254 of them were perished. So here, the defendants were held liable for the loss of the pigs but not for loss of profits from future sales of pigs. The loss of pigs was a physical injury and the court, feeling that for such injuries the principle should be the same as in tort, the defendants were liable for all damage which could reasonably have been foreseen at the date of the breach as a possible consequence of the breach. Thus, the loss of profits was an economic loss, and the defendants were not liable for it because it could not have been within the parties' contemplation at the time of the contract. Thus, the opinion of the Court of Appeal is that Hadley versus Baxendale should be confined to economic loss, and for physical injuries, the principle of foreseeability, which operates in tort, should apply. Now, talking about the Section 73 of the Contract Act, we see that the same principles are applicable in India too. The Privy Council, for example, has observed in the case of AKAS Jamal versus Mullah Daud Sons and Co. that Section 73 is declaratory of the common law as to damages. Similarly, Justice Patanjali Sastri of the Supreme Court has observed in Panna Lal Janki Das versus Mohan Lal that the party in breach must make compensation in respect of the direct consequences flowing from the breach and not in respect of loss or damage indirectly or remotely caused. The section provides that compensation for loss or damage caused by breach of contract. When a contract has been broken, the party who suffers by such breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him thereby, which naturally arose in the usual course of things from such breach or which the parties knew when they made the contract to be likely to result from the breach of it. Such compensation is not to be given for any remote and indirect loss or damage sustained by reason of the breach. Compensation for failure to discharge obligation resembling those created by contract. When an obligation resembling those created by contract has been incurred and has not been discharged, then any person injured by the failure to discharge it is entitled to receive the same compensation from the party in default as if such person had contracted to discharge it and had broken his contract. Now it has an explanation which we would see in the later part of this discussion, and it says in estimating the loss or damage arising from a breach of contract, the means which existed of remedying the inconvenience caused by the non-performance of the contract must be taken into account. So this section has 18 illustrations, each highlighting a different category of cases, which I am skipping so as to save the time of this lecture. But I would suggest you to go on to read the same after this lecture. Now, a question has been asked in UPPCSA 2013. It said damages allowed under Section 73 of the Indian Contract Act are, and we know that in Section 73, these are the compensatory damages which have been mentioned, not the penal ones, which come in Section 74. So, as held in state of Rajasthan versus Nathula, this section declares that compensation is not to be given for any remote or indirect loss or damage sustained by the reason of the breach. The section also provides that the same principles will apply when there has been a breach of a quasi-contractual obligation. Thus, Section 73 incorporates two rules of Hadley versus Baxendale. Compensation is recoverable for any loss or damage, either one, number one, arising naturally in the usual course of things from the breach, or number two, which the parties knew at the time of the contract as likely to result from the breach. So the first rule, as we see, is objective, as it makes the liability to depend upon a reasonable man's foresight of the loss that will naturally result from the breach of the contract. The second rule, however, is subjective, as according to it, the extent of liability depends upon the knowledge of the parties at the time of the contract about the probable result of the breach. It has also been held in Draupadi Devi versus Union of India that the burden of proof lies on the plaintiff to show that the damage has been sustained and what shall be the measure of converting the loss into money. A claim for damages becomes liable to be rejected when this burden is not discharged. Now, the extent of liability in ordinary cases is what may be foreseen by the hypothetical reasonable man as arising naturally in the usual course of things. One illustration is the decision of the Madras High Court in Madras Railway Co. versus Govinda Rao, and in this case, the plaintiff, who was a tailor, delivered a sewing machine and some clothes to the defendant railway company to be sent to a place where he expected to carry on his business with special profit by reason of a forthcoming festival. To the fault of the company's servants, the goods were delayed in transmission and were not delivered until some days after the conclusion of the festival. The plaintiff had given no notice to the company of his special purpose. He claimed as damages the expenses of travelling up to the place of festival and of staying there and the loss of profits which he would have earned. The court held that the damages claimed were too remote. All of these were due to the frustration of the special purpose, and that was not known to the company. So, on the idea of profit of loss where it is necessary, as it has been held in Chief Secretary State of Gujarat versus Kothari and Associates, that in a claim for general damages, the plaintiff has to assert that he has suffered some loss, but for the purpose of claiming special damages, he has specifically to plead that and prove that he has sustained such special loss, and whether actual purchase or sale of goods is necessary on this given idea. The High Court of Delhi has been of the view in the case of Union of India versus Commercial Metal Corporation that it is not necessary that on default by the seller to deliver, the plaintiff should have actually brought the goods elsewhere and not only and only then claim the difference. So the court said that the damages could be claimed on market basis. Now, talking about an idea where there has been premature termination of contract. In Engineering Projects India Limited versus BK Constructions, a clause in the contract provided for compensation for delay in completion. The contract was terminated before it could be completed and also before the completion period was over. The court said that no compensation could be claimed from the contractor. No evidence was offered here, which was of additional cost, and if any, for setting the work completed from other sources. Further, in relation to incomplete execution, in the case of MSK projects versus State of Rajasthan, a road building contract was to be executed in two phases, and the second phase was never executed by the contractor. Here, he was fully paid for completion of the first phase. The contractor was not allowed to claim compensation for not doing the work on the second phase just by showing technicalities. Now, in relation of award of interest on difference, in Cotton Corporation of India Limited versus Alagappa Cotton Mills, where because of the purchaser's breach, the supplier had to resell the goods elsewhere and became entitled to recover the difference, the court allowed future interest at 20% per annum from the date of the suit till the date of judgment and 6% per annum from the date of judgment till realization. Now, can there be interest given by way of damages? So it has been seen in Macon Limited versus Pioneer Fabricators where that payments of running bills were delayed in breach of contract terms. So the contract had taken loan at 13.25% interest and he was awarded interest for the period of delay at 12.5%. This was held to be proper, the time period between raising of bill and payment being not very large. Where loss of profits is special loss, we see that loss of profits which are to accrue upon resale cannot be recovered unless it is communicated to the other party that the goods are for resale upon a special contract. This is borne out by the decision of the Supreme Court in the case of Karshan Das H. Thakur versus Saran Engineering Co. Limited. Over here, we see that there was a contract to supply 200 tons of scrap iron. The buyer undertook to supply the same quantity to the Export Corporation in Calcutta. The seller failed to supply, and in consequence, the buyer could not keep his date with the corporation. The corporation recovered from him this difference between the contract price and the market price. The seller contended that he should not be held liable for anything because control price of iron scrap was still the same and he had no knowledge of the contract of resale to the corporation. The court found the facts of the case to be similar to illustration K, according to which the seller has not to pay any compensation that the buyer may have to pay to his buyers by reason of the breach unless he was made aware of the buyer's promise at the time of the contract. Here, Justice Raghubar Dayal said that on account of non-delivery of scrap iron, he, that is the buyer, could have purchased the scrap iron from the market at the same control price and similar incidental charges. This means that he did not stand to pay a higher price than what he was to pay to the respondent, that is the seller, and therefore he could not have suffered any loss on account of the breach. The actual loss which he suffered on account of the breach was the result of his contracting to sell 200 tons of scrap iron for export to the Export Corporation. As the seller did not know this contract, he could not have known of the likelihood of the loss he actually suffered. So, consequences of delay in transit has also become one category of cases where we see that consequences of delay in transit in the case of Union of India versus Steel Stockholders Syndicate. Here, a consignment of goods with the railways reached its destination after inordinate delay caused by gross negligence of 7 months. The plaintiff's money remained blocked for the period. In this case, he was allowed to recover interest on the money by way of damages for the loss. So now that we have covered the first major category, that was remoteness of damage, we are going to talk about measure of damages now. So, once it is determined whether general or special damages have to be recovered, they have to be evaluated in terms of money. And this is the problem of measure of damages and is governed by some fundamental principles. So, to begin with, the claim for damages is not debt. And it has been held in Green Hills Export versus Coffee Board that a claim for damages arising out of breach of contract, whether for general or liquidated damages, remains only a claim till its adjudication by the court and becomes a debt only after the court awards it. Till then, and on that basis of the claim alone, the claimant is not entitled to present a winding up petition of the defendant company on the ground of its inability to pay debts. So, secondly, we see that the damages are compensatory, not penal. In the words of Justice Asquith in the case of Victoria Laundry versus Newman Industries, it is a well settled principle that the governing purpose of damages is to put the party whose rights have been violated in the same position so far as money can do so, as if his rights have been observed. So, there is obviously the idea of inconvenience caused by breach, in that in the case of Hobbs versus London and South Western Railway Co., we see that where a train pulled its passengers to a wrong direction, and consequently the plaintiff and his wife, finding no other conveyance nor a place to stay, had to walk home at midnight. The jury allowed £8 as the damages for the inconvenience suffered by the plaintiffs in being obliged to walk, and $20 in respect of the wife's illness caused by catching a cold. On appeal, the Court of Queen's Bench held that the £8 was properly awarded but not the £20. So the inconvenience of walking back must be taken to have been within the reasonable contemplation of the parties, but the wife's cold was not necessary or even the probable consequence of the breach. But in the subsequent case of McMahon versus Fields, the above decision was criticized and damages were allowed when the plaintiff's horses were turned out of the defendant's stable in breach of contract and then they caught a cold before an alternative accommodation could be found for them. We also have cases where loss has been caused by misrepresentation. So, the price at which a thing is purchased and its difference with the real value when misrepresentation about it is discovered is the yardstick for compensation. In Norton versus Oak Callion, a horse was purchased described as fit for races, but it turned out to be different breed. That was discovered after a long process of trial and error, and after discovery its market value was much less. It was held that where an article purchased as a result of misrepresentation could have been resold immediately after the sale for the price paid, but by the time the misrepresentation was discovered, its value had fallen by reason of a defect in it, which had then become apparent. The appropriate measures of damages would be the difference between the purchase price and its value at the time when misrepresentation is discovered, and not the difference between the purchase price and its actual value at the time of purchase. Now, in cases where there is only nominal damages, that is, it's a no loss situation. So, on that note, I've got for you the authority of T.A. Chaudhary versus State of Andhra Pradesh, where it has been held that where the plaintiff suffers no loss, the court may still award him nominal damages in recognition of his right. But this is in the discretion of the court. The court may altogether refuse to award any damages or may award even substantial damages. The court is competent to award reasonable compensation in case of breach, even if no actual damage is proved or shown to have been suffered in consequence of breach of contract. Now, what about compensation in no loss situations? So, for that, we see in the case of Experience Hendricks LLC versus PPX Enterprises, an action was brought for breach of contract arising out of overuse of musical recordings. The court generally orders in such cases an account of profits made in overuse, but in this case, the breach had caused no economic loss, and hence the court said that although the court could order an account of profit for breach of contract where the claimant could not prove that it had suffered any financial loss, this would only be done in exceptional circumstances such as national security, exceptional profits, and fiduciary breaches. Damages could be awarded for a breach of a restriction which had been imposed to protect the claimant's property, where an injunction was refused because the court was only concerned with past profits. But this was not an exceptional case which justified an account of profits. Even so, the defendant should make a reasonable and substantial payment for the unauthorized use of a master records. Now, a question has been asked in UPPCs in 1999, and it said, is plaintiff entitled to damages for mental distress and social stigma caused due to breach of contract? So, students, following this lecture within the next 10 minutes, I'm sure you'd be able to thoroughly answer this question. So, accordingly, we are going to deal with the category of mental pain and suffering and punitive damages, that is, non pecuniary loss. So, it has been held in Withers versus General Theatre Corporation Limited that in ordinary cases, damages for mental pain and suffering caused by the breach are not allowed. It is not appropriate to award damages for anguish and vexation caused by breach of contract when the contract is an ordinary commercial one, but they may say that it may be allowed in special cases. For example, in Westtosen versus Olathe State Bank, the defendant, a banking corporation, agreed to loan the plaintiff money for a trip to California by crediting his account with such sums as he might need after reaching his destination. The plaintiff reached California, but the defendant refused to give him the promised credit. The court allowed damages for humiliation and mental suffering. The banker could have foreseen that the plaintiff, having gone away from home and among strangers on the basis of the promise, would naturally suffer mental anguish if his check was not honored. Now, in relation to this given category, there is an idea that is three cases listed by the House of Lords. So, what are these three cases in which such exemption can be honored? So, the House of Lords in Addis versus Gramophone Co. Limited has listed three situations in which mental pain and suffering can be taken into account. There are three well known exceptions to the general rule, namely actions against a banker for refusing to pay a customer's check when he has in his hands funds of the customer to meet it, and actions for breach of promise of marriage. They are now abolished in England, and actions where the vendor of real estate fails to make title. So, Lord Atkinson then added in this case that he knew of none other and that any tendency to create a fourth exception should be checked rather than stimulated. His lordship warned that application of tort principles to contract would lead to confusion, uncertainty, and anomalies, and occasionally to injustice too, and hence make the law a still more lawless science than it is said to be. Suppose, for example, that a debtor refused to pay his creditor. Should the damages be refused if the debtor is helpless and apologetic and increased if the refusal is from a malicious desire to injure the creditor? So, on this note, His Lordship expressed the opinion that these matters should not play any part in the law of contract, where the principle is that the aggrieved party is to be paid adequate compensation in money for the loss of that which he would have received had his contract been kept, and no more. The facts of this case was such that the plaintiff was employed by the defendant company at a certain salary and commission on a trade done. He could be dismissed by 6 months' notice. He was given 6 months' notice, and at the same time, another person was appointed to his place, thus preventing him from acting as manager even for the notice period and earning his commission. Here, the House of Lords rejected the claim for damages for the humiliating manner of dismissal, but allowed damages for the commission and salary which he had lost. The damages the plaintiff sustained by his illegal dismissal were the wages for the period of 6 months, the profits on commission which would in all probability have been earned by him, and possibly damages in respect of time which might reasonably elapse before he could obtain other employment. Now, moving on to the category where compensation is given for non pecuniary loss. So, the House of Lords, in their decision in Farley versus Skinner, has held that there is no reason why compensation for non pecuniary damage should not be allowed. In this case, the claimant was considering the purchase of a tranquil country property. So, he instructed a surveyor to report on the volume of aircraft noise in the area. The surveyor negligently reported that the property was unlikely to be affected by the noise. The claimant bought the property and subsequently discovered that it was significantly affected by such noise. He stayed in the property and brought an action against the surveyor to recover compensation for non-pecuniary loss caused by inconvenience. So here, their lordship approved the award of £10,000 as damages for breach of a contractual duty of care in respect of the survey report. Their lordship said that where a surveyor gives the contractual undertaking to investigate a matter important to the buyer's peace of mind, the buyer is, in principle, entitled to recover non pecuniary damages for breach of that undertaking. He said that there is no reason why the scope of recovery should depend upon the object of the contract as ascertained from all its constituent parts. It is sufficient that a major or important object of the contract is to give pleasure, relaxation, or peace of mind. Such a claim is also not barred by the fact that the surveyor undertook only to exercise reasonable care rather than to guarantee the achievement of a result. It would be a singularly unattractive result if a professional person who undertakes a specific obligation to exercise reasonable care to investigate a matter which his client told him to be important could release himself even by non performance when his very payment was a part of the consideration for that performance. The fact that the claimant nevertheless chose to stay there could not deprive him of his right because it was no justification for the surveyor's breach of duty. Lord Stein advised a caution that awards of non-pecuniary damages should be restrained and modest. It is important here that logical and beneficial developments in the law should not contribute to the creation of a society bent on litigation. Now, this judgment is very important in relation to the given subject. In fact, even the earlier judgment, that is the Addis one, it is very much important in relation to any case that may come up in relation to mental pain and suffering. And as you can realize by now, after I mentioned a question that has been asked on the very category of mental pain and suffering previously, now in the coming examination too, you can absolutely expect such a question. So, student, you see what I'm trying to do over here is actually bring to your attention every such important category on which a question can be asked. Now, in relation to damages for breach of confidence, we see in Fraser versus Thames Television Limited that three actresses formed a rock group. They conceived an idea of producing a television serial based on their experience to focus attention on their individual and group life so as to contrast their collective character with their individual character. The idea was conveyed in the course of oral negotiations to a television company. This resulted in a written agreement which provided some payment to the ladies but forbade the company from using the idea unless the ladies were given the opportunity to act, and they declined it. Without giving the opportunity, the company produced the program with great commercial success. The company in this case was held liable in damages to the ladies. The agreement contained an implied negative covenant. The circumstances in which it was communicated imported an obligation of confidence. The content of the idea was clearly identifiable, original, of potential commercial attractiveness, and capable of reaching fruition. Now, we're going to talk about the case where there is injunction required for restraining breach of content. So for restraining breach of contract. So in the case of Bombay Motor Stores versus Union of India, where a supply system to the army which had been going on since 1960 was not allowed to be scrapped all of a sudden by blacklisting the supplier, it was held that a person dealing with the government in matters of sale and purchase develops legitimate interest and expectations. The order of blacklisting amounted to denial of equality of opportunity, and before issuing such an order, some explanation should have been called for. The court would not interfere in the matter if it is decided again by giving opportunity to the supplier. Now, in relation to impact of inflation on damages, we see in the case of Doyle versus Nichols, the court took into account the likely impact of inflation while awarding damages to the widow of a doctor in respect of his death in a road accident. The House of Lords had expressed the opinion in Taylor versus O'Connor that if there was a firm basis for the conclusion that the awardee would be affected by future inflation, the court should take into account as best as it could. So, basing this given opinion of the House of Lords in the case of Taylor versus O'Connor, in this case of Doyle versus Nichols, where the victim of the accident was a salaried employee and his salary would have naturally increased according to the rate of inflation, it was held in this case of Doyle versus Nichols that his dependents would suffer obvious injustice if their dependency figure was not increased accordingly. Now, In UPPCSJ 1991, right in 1991, this question was asked that what principles have been incorporated in the Indian Contract Act of 72 for determining the amount of damages to be awarded in the event of breach of contract, discussed in the light of decided cases. So, in this question, students, we need to mention Section 73 and its explanation, of course. Then we need to cite the case of Karsandas H. Thacker versus Saran Engineering Co. Limited. Then we need to thoroughly explain the rule regarding measurement of damages as enunciated in Hadley versus Baxendale. Moving on, we need to also explain the assessment of damages and finally conclude this answer with the object of compensation as mentioned in the case of Victoria Laundry Limited versus Newman Industries Limited. Now, talking about the duty to mitigate as mentioned under section 73 as an explanation. So the explanation attached to section 73 provides for the duty to mitigate damages. It says, in estimating the loss or damage arising from breach of contract, the means which existed of remedying the inconvenience caused by the non-performance of the contract must be taken into account. So the injured party has to make reasonable efforts to avoid the losses resulting from the breach so that his loss is kept to the minimum. The most frequent application of this rule takes place in contracts for sale or purchase of goods, as held in the case of PSNS Ambalavan Chetir versus Express Newspapers Limited. On the buyer's refusal to take delivery, the seller should resell the goods at the prevailing market price and he may then recover from the defaulting buyer as damages the difference between the price he realized and the price he would have received under the contract. If the seller does not resell the goods and his loss is aggravated by the falling market, he then cannot recover the enhanced loss. The well-known authority for this proposition is the decision of the Privy Council in the case of AKAS Jamal versus Mula Datwood Sons and Co. So, in this case, the plaintiff had contracted to sell to the defendants 23,500 shares to be delivered and paid for on December 30, 1911. The shares were tendered on this date, but the defendants declined to take delivery or to pay for them. At the market prices for sales upon that day, the shares would have realized rupees 1 lakh, more than rupees 1 lakh, less than their price under the contract. But the plaintiff sold the shares and only after February when the market was again rising and he realized only rupees 79,000, less than the price under the contract. So the defendants then contended that they should be liable to pay the loss of only rupees 79,000. But he was held liable for more than rupees 1 lakh 9,000. And Lord Renberry explained the principles of law thus. It is undoubted law that a plaintiff who sues for damages owes the duty of taking all reasonable steps to mitigate the loss subsequent upon the contract and cannot claim as damages any sum which is due to his own neglect. But the loss to be ascertained is the loss at the date of the breach. Further, on the idea of contract of employment and duty of mitigation, we see that the duty of mitigation also finds its application in reference to premature termination of a contract of employment. Thus, in Brace versus Calder, where on account of the retirement of 2 out of 4 partners, a partnership firm was ended and with it the services of the manager, but the remaining 2 partners reconstituted the firm and offered him employment on identical terms, which he refused to accept and instead brought an action for damages. Here, it was held that he should have accepted the employment in mitigation of his loss and that he was entitled to only nominal damages. Further, the reluctance of courts to expand scope of duty of litigation also needs to be emphasized upon. So, in Paula Lee Limited versus Robert Zahel and Co. Limited, we see that where the distribution of a dress manufacturer agreed to purchase a given number of garments in 2 seasons, he had complete freedom to choose garments of any variety and to resell them in his area at any price. The distributor repudiated the contract and he was sued for breach. He argued that he should be called upon to pay damages for manufacturers' loss of profits on their cheapest garments because he had the freedom to choose any garments. The court then said that since it could not have been in the contemplation of the parties that the distributor would stock only the minimum priced garments, which would have been destructive of the market, damages must be computed on the basis of a reasonable criterion which should also be the least unfavorable to the distributor. And lastly, in today's lecture, talking about contributory negligence, we see that in contract claims, the duty to keep one's loss to the minimum is capable of taking care of the matter where the loss is either caused or increased by the claimant's contributory negligence. But where the defendant's liability in contract is the same as his liability in the tort of negligence, then independent of the existence of any contract, the court has the power to apportion blame and to reduce the damages recoverable by the plaintiff, even though the claim is made in contract. We see this approach being adopted in the case of Vesta versus Butcher, where in a principal's action against his agent for breach of agent's duty in circumstances in which the principal failed to rectify the matters during the subsequent opportunities available to him. So that sums up this given lecture, students, as a part of which I have covered with you section 73 of Indian Contract Act of 1872. Now this is a very important section and you can expect a question from this given section. I hope that you find everything that I have discussed with you today pretty useful, and I would definitely suggest you, as always, to keep on revising whatever that we go through. Thank you. Take care.